Good morning, this is your Kelso Report for Tuesday, December 11th, and I'm your host, Clark Kelso. Good to have you with us. Our first case today is from the United States Supreme Court and involves the jurisdiction of federal courts to review adverse personnel actions by federal agencies. Then we turn to a decision from the Ninth Circuit involving standing to challenge civil forfeitures, and we have two state cases, the first involving the procedure for seeking relief from three-strike sentences in light of Proposition 36, and a case involving jury instructions in a pregnancy discrimination action. We begin with the Supreme Court. Judicial review of agency action is generally governed by federal statutes that waive the federal government's sovereign immunity and at the same time establish jurisdiction in one or another federal court. Sometimes jurisdiction lies with the federal circuit, sometimes with a district court, sometimes with the Court of Claims. Jurisdiction to review certain personnel decisions was the issue before the Supreme Court in Kleckner v. Salas. As a general matter, a federal employee subjected to an adverse personnel action, such as a discharge or demotion, may appeal her agency's decision to the Merit Systems Protection Board. In that challenge, the employee may claim, among other things, that the agency discriminated against her in violation of a federal statute. Other statutes then provide that judicial review of a simple board decision not involving discrimination claims is taken to the federal circuit. However, in a mixed case where the employee has raised discrimination claims, judicial review may be had by filing in the district court under the applicable anti-discrimination law. The employee in the case before the court had a mixed case, but managed to have her board proceeding dismissed on purely procedural grounds. The question then arose whether she should seek judicial review in the federal circuit or instead bring a suit in district court. She sued in the district court, but that court dismissed her action for lack of jurisdiction. The Eighth Circuit affirmed, holding she should have appealed the board's decision to the federal circuit. Well, the Supreme Court unanimously reversed. The court noted that some of the procedures spelled out in the civil service law can be confusing, but in this case, the court explained, the result is a straightforward application of the plain meaning of the statutes. The government had tried to argue that all procedural rulings should somehow be channeled to the federal circuit, while merits decisions in cases involving anti-discrimination allegations would go to the district court. The court rejected this argument, explaining that, quote, "We return from the government's maze-like tour of the act, persuaded only that the merits procedure distinction is a contrivance," close quote. They weren't very pleased with the government's argument. Interestingly, of course, it was a contrivance that fooled both the district court and the Eighth Circuit. But of course, that's why we have the Supreme Court to clarify those sort of things. Next, we turn to a decision from the Ninth Circuit involving civil forfeitures. Successfully attacking a civil forfeiture can be procedurally and substantively pretty challenging. Even the question of what it takes to allege standing has wrinkles. In United States v. Simard, the government had seized property from the claimant, who then filed a claim to $999,830, that's a lot of cash he had, in a civil forfeiture proceeding. Although his petition unequivocally alleged ownership of the monies that had been seized from him, the district court struck his claim by relying upon statements the claimant allegedly made at the time the money was seized, where he had asserted a mere possessory interest instead of an ownership interest. Well, the problem for the claimant was, when a mere possessory interest is claimed, standing can be established only if the claimant actually explains how he or she came into possession of the property. An explanation that is not required when ownership is alleged. Well, the claimant's petition in this case did not provide any explanation of how he came into $999,000 cash and was carrying it around with him. It just asserted ownership. He didn't want to explain where that money came from. The Ninth Circuit reversed the district court's dismissal of his claim for the money, holding that the district court should not have relied at this stage of the proceedings, a motion to dismiss, on statements allegedly made by the claimant when the monies were seized. In this case, standing clearly was established by the claimant's unequivocal assertion of ownership. That should have been enough to get by the motion to dismiss. Next, we turn to some state criminal procedure. When criminal statutes change to lessen the extent of punishment, the question always arises to what extent the changes are effective retroactively. Well, in the case of recently enacted Proposition 36, which significantly modifies the three strikes law by requiring, among other things, that the third strike be a violent or serious felony, the proposition itself specified that inmates who have already been sentenced and whose sentences are final or pending on appeal may file a petition in the trial court to recall their sentence for reconsideration. In People v. Conley, the 3rd District dealt with a case where their opinion on appeal had already become final at the time of the election, and the appellant then filed a petition for reconsideration in light of Proposition 36. The 3rd District republished its earlier unpublished decision solely to clarify that the proper procedure here is a petition to recall in the trial court, not a motion for reconsideration in the appellate court. We're going to channel all of these decisions back to the trial court for its initial determination. Next, we have an employment discrimination case. Jury instructions were the focus of attention here in an unusual pregnancy discrimination case in Veronese versus Lucasfilm. The case is factually unusual because the interactions between plaintiff and defendant's representatives were relatively brief, over a period of less than 4 months. Save for 4 in-person interviews or meetings, most of these interactions were by email, so there was a clear record here, and the plaintiff never even worked 1 day in defendant's employ. Nevertheless, after 3 days of deliberation, the jury found for the plaintiff on 3 claims: pregnancy discrimination, failure to prevent pregnancy discrimination, which is an independent tort, and wrongful termination and violation of public policy. The jury found for Lucasfilm on 2 other claims: retaliation and failure to accommodate disability. The jury awarded the plaintiff $93,000 for past economic damages and $20,000 non-economic. The trial court later awarded plaintiff $1.2 million in attorney's fees. Well, the 1st District reversed the entire judgment because of prejudicial errors in instructing the jury. First, the trial court failed to give a requested business judgment instruction, which would have read as follows, quote, "You may not find that Lucasfilm discriminated or retaliated against Julie Gilman Veronese based upon a belief that Lucasfilm made a wrong or unfair decision. Likewise, you cannot find liability for discrimination or retaliation if you find that Lucasfilm made an error in business judgment. Instead, Lucasfilm can only be liable if the decisions made were motivated by discrimination or retaliation related to her being pregnant." Close quote. Well, this business judgment instruction is supported by multiple state and federal cases, and the failure to give it was clearly prejudicial. Now, in addition, the trial court failed to instruct the jury at all on the failure to prevent pregnancy discrimination or on the wrongful termination claims. And these failures to instruct were also prejudicial. And the court's supposed to help the jury out and give them instructions on each claim. There is here a very good lesson for plaintiff counsel. A jury verdict secured through prejudicially erroneous jury instructions really doesn't help your client in the long run. You need to make sure you can hold your judgment on appeal. And that's it for today's Kelso Report. Have a great day in the law. We'll see you tomorrow morning.